Hi, this is Chris Whitelaw of Commercial Disputes Management Center. Today I'd like to talk about the topic of commercial disputes and distinguish between what are called rights-based disputes and interest-based disputes. This is a very important distinction to make when it comes to considering how a commercial dispute might be managed early to avoid the parties getting locked into litigation and bringing the dispute into the courts. Lawyers tend to mainly focus on what a client's rights are. And so, for example, if you have a contract and it spells out the rights of each party and their obligations under the contract, and at some point one of the parties says that the other party is not observing their obligations, that activates a right for the aggrieved party under the contract to do something about that. Another example, for instance, is if you have a right given to you by some act of Parliament, like under the Trademarks Act or under the Copyright Act, those give you rights to certain copyright, rights to own a registered trademark, and to use it exclusively. So if you then were to find that someone else was infringing your copyright or infringing your trademark, you would go to your lawyer and they would say, yes, those are your rights and you have a cause of action and you can pursue that cause of action. So that's just an example of a few examples of what a rights-based dispute could be about. Now the important point is this: when it comes to commercial disputes, we need to go bigger than that. We need to start off at the very beginning in understanding that together with looking at each party's particular rights, what are their commercial interests? What's the commercial interests of party A and party B, and how are those sets of commercial interests possibly interlocked for mutual benefit? Now, when a dispute emerges, one thing that, in my opinion, is extremely important is that you go to someone to give you initial advice about what your options are, what is open to you to do in relation to some potential infringement of a right, that understands how to blend that with looking at your commercial interests. This is something that is generally overlooked by many, many lawyers. The view I take is this: if I have a commercial client and the commercial client comes to see me for advice, obviously I want to talk to the client about what his or her rights are, or the company's rights and so on. But the very next area I will get into is, what are your interests here? What are your interests that lie behind this dispute that's happening? How long have you been in business with this other party? What's your relationships? What have been your relationships over the past few years? How important are those relationships to you? This has to be understood in the context and at the same time as discussing rights and breaches of rights or infringements of rights. Now, if that discussion is left out and all that a legal advisor does is look at the facts about your rights, before you know it, letters are possibly being written, communications are happening, which start to polarize the two parties and starts to drive a wedge between them. This is the typical scenario that leads to litigation. In Commercial Disputes Management Center, we try to do things differently in commercial disputes. And I make a big distinction here between commercial disputes and other non-commercial disputes because of the factor of commercial interests. What's extremely important is to help the client put things in proper context. So, for example, if the situation at hand is a breach of a contract between two businesses, and the exploring the facts with the client reveals that there's been a long, profitable relationship between the two businesses, technically there is a breach of the contract. But the instructions of the client is that they value this commercial relationship and they would rather not lose it. They would like it to continue into the future. If that's the case, then it behoves the person giving the advice to be extremely careful to try to get that right balance between preserving someone's rights that are there and looking after their commercial interests. And that's why we say in the way that we work that preserving commercial relationships always is kept out front. Obviously, if there's a different situation at hand where maybe the two businesses are total strangers to each other and maybe they're competitors. And one of the businesses has some important copyright ownership and has some important trademarks. And they suddenly find out that another business is misusing them, infringing them. Well, clearly, that's an important commercial right that's being breached and may cause damage. That's a very different situation. In that particular context, what the client wants is swift action to protect that right, because it's the protection of that right that actually is the thing that is the most important thing to their commercial interests. So I'm just distinguishing those two situations. But there are many, many commercial disputes that come through the door to a legal advisor that are between businesses that have been in business with each other for a period of time. And they are a special context where the underlying commercial interests must be very carefully understood before any legal advice is given to the client about taking precipitous action to enforce a right or to protect a right that may, if done in the wrong way, without regard to the broader context of the intertwined commercial interests, cause damage to vital commercial interests. In that instance, really it comes down to the metaphor of shooting yourself in the foot. So I hope I've managed to clarify that difference, that important difference between rights involved in a dispute, legal rights, strict legal rights, and commercial interests. And if you'd like to know more about that, just give us a call and I'd be happy to talk to you more about it.